My name's Ted Smith. I'm the Dean of Academic Affairs here at the college, and we welcome you to what we hope will become a growing annual event here at JCC as we choose to honor the work of a native son, Robert Jackson, who, as you all know from the sheet in front of you at your place setting, was a justice of the Supreme Court, a prominent attorney in Jamestown. Apparently, as I understand it from some of his family members, the only case he ever lost, he lost in Jamestown. And as the sheet says, the total value of that apparently was $75, or so I'm told. Anyway, we are choosing to honor him, as are other groups in the greater Jamestown area. And I think it's fair to say that in the next couple of years or thereabouts, you're likely to see some renewed interest locally in Robert Jackson and his work, not only in the Supreme Court, but also his work as Attorney General of the United States and others. It's my duty this afternoon to introduce to you Professor Gregory Rabb from our Political Science Department, who himself is going to be on sabbatical leave from the college next year and will be doing a lot more scholarly work in researching some of Robert Jackson's work. So Greg Rabb will introduce our speaker today, and so will you please meet and greet Professor Greg Rabb.
Thanks, Todd. I'm losing my voice because of allergies, so I won't talk a lot. Several years ago, when we got a grant from the New York State Commission on the Bicentennial of the United States Constitution, one of the things we wanted to do with the grant was to do a program on Justice Jackson and at least, at minimum, bring a speaker down who could talk to us about Justice Jackson's contribution to American law and jurisprudence. And one of the most frustrating things for me at that time was we had trouble finding people who were doing current research on Robert Jackson. And we uncovered what I thought was a serious lack in terms of scholarship and research. Fortunately, as Ted has mentioned, that is slowly starting to correct itself as people start to rediscover the contributions that Mr. Jackson has made. Spent a lot of time researching and writing about it as our speaker. Before I introduce him, I would just like to point out that he is going to be speaking this evening at 7 p.m. in the library building on the second floor in room 271. The lecture is free and open to the public, and in fact, Professor Hockett's lecture tonight will be a much more extended version of what he will be able to share with us this afternoon. So if he tantalizes you with knowing more about Jackson, as often the more I find out, the more tantalized I get, please, if you're free tonight, come and join us. We'd be glad to have you. Jeffrey Hockett is a professor right now at the University of Tulsa. He holds a PhD in government and an MA in government from the University of Virginia and a BA in political science from Knox College. I won't let you know everything about his background. I will point out, though, that in the Supreme Court Review from 1990, he wrote an article entitled Justice Robert H. Jackson, the Supreme Court and the Nuremberg Trial. That's how I first became aware of Professor Hockett's work. Read the article and found it very interesting. And so, in fact, what we've asked Professor Hockett to do was to share with us some of what he learned from that article. And so let me present to you Professor Jeffrey Hockett.
Thank you. Let me point out, just add to Greg's comments about my talk this evening, this is actually not a compressed version of everything I'll be talking about tonight. It's actually the first third of what I'll be talking about tonight, so I won't give you everything at this talk. If you don't like what I'm going to talk about here, then best not show up for the rest of it this evening, and even though it's not duplicated. But first, let me thank you for the opportunity to speak about one of the Jamestown Bar's more famous members, who served as the nation's Solicitor General and then Attorney General before his appointment to the court in 1941. Robert Jackson has been a research interest of mine for about the past 6 years, and through my work, I'm attempting to give him the scholarly attention that he deserves, but for some peculiar reason has been denied in the literature of public law. I'm not quite sure why this is the case, that he's been ignored to the extent that he has. My guess is that he voted frequently with Felix Frankfurter, and so people tend to associate him with Frankfurter, and so they ignore Jackson, which is a big mistake. Jackson was certainly one of the most interesting and colorful individuals ever appointed to the Supreme Court. He was one of the last justices to be schooled in the law in the traditional manner, and by that I mean through apprenticeship. He apprenticed for 2 years under Frank Mott, who was a well-known Jamestown attorney. He also went to Albany Law School for 1 year, but I think it's fair to say that he received most of his training in Frank Mott's office. And Jackson was undoubtedly one of the most gifted writers ever to serve on the court. In fact, I think this is what he's best known for, is the style of his opinions. Only Benjamin Cardozo's opinions rivaled the brilliance and force of Jackson's prose, and I think it's even debatable whether Cardozo was better than Jackson. Typically people say Cardozo was the best stylist, but I think that Jackson had a tendency to write elegantly without being pretentious, which I guess suggests that I think at times Cardozo was pretentious. But Jackson's felicity of expression, no doubt, was the result of the rough and tumble training that he received at the Jamestown bar. Litigation, I say that only half in jest because litigation was the primary source of public entertainment in Jamestown during Jackson's years as a country lawyer, which included the years 1913 to 1933. And the most successful attorneys, that is, those who could win not only the immediate case, the case before them, but also the respect and confidence of those viewing the trial, were those who were skilled as orators. Jackson apparently impressed many people, as his legal practice earned him around $30,000 per year during the depths of the Depression, and he also said it was significantly more that he earned per year in non-Depression years. I think Jackson would have been interested to find out that it was 1990 before the salaries of assistant professors matched his Depression-era earnings. And I shudder to think what Jamestown attorneys are making today, and I'm not going to ask for fear of being depressed. Now, there's much to discuss concerning Jackson's fascinating background and his career as a justice of the Supreme Court, but what I would like to discuss with you is his extrajudicial involvement, that is, his off-the-bench involvement in one of the greatest trials in history. And I'm referring, of course, to Jackson's involvement as United States Chief of Counsel for the prosecution of the Axis war criminals. Jackson was appointed to this position by President Truman, and the assignment occupied Jackson from June of 1945 until October the following year, which means, of course, that he missed all of the Supreme Court's 1945-46 term, which did not endear him to his colleagues, especially Chief Justice Stone. I'll talk about that tonight. I just don't have time to talk about it this afternoon. What I want to focus on specifically this afternoon is what I think would be of most interest to this audience, namely the legal argument for trying the Nazis as war criminals. Jackson considered the Nuremberg Trial as a landmark in international law, since it was at Nuremberg that individuals were first held responsible for waging a war of aggression and for committing crimes against humanity, or genocide. It was the first time this happened. Many others, however, disagreed with Jackson. They argued that the trial was a negation of principles that lie at the heart of any system of justice under law. That is, these critics argued that it was a political court, one that was merely organized to convict the Nazis. Even Chief Justice Harlan Stone, one would think he would support Jackson in this, Harlan Stone privately characterized this trial as a high-grade lynching party. He didn't say this to the news, but he said it in his correspondence to his acquaintances. Now, what I would like to do in this talk is to, again, examine the legal argument that Jackson used to prosecute the Nazi war criminals. And the standard by which to judge the fairness of this or any other trial is found in the fundamental legal principle, no crime and no punishment without pre-existing law. That is, no retroactive legislation, or as it's stated in our Constitution, no ex post facto laws. Critics of the Nuremberg trial anticipated serious retroactivity problems given the nascent state of international law, and they argued that any trial of the Nazis would be political for that reason. Something, of course, had to be done with the Nazis. They could not just be let go. But these critics called instead of a trial, they called for retribution not connected to judicial procedures, namely summary justice. That's what they wanted. They argued that the justice of the firing squad would render a deserved punishment without compromising legal values and judicial prestige. Now, Jackson pointed out there's a certain problem with this, though. He pointed out that summary justice would violate another important juridical principle, namely that there must be no punishment without demonstrated proof of a criminal act. In Jackson's words, he said, undiscriminating executions or punishment without definite findings of guilt fairly arrived at would not set easily on the American conscience or be remembered by our children with pride. Furthermore, Jackson noted that punishment without public proof of individual wrongdoing and an opportunity for the accused to defend themselves risk creating a myth of martyrdom. That is, Jackson feared a resurgence of fascism at some later date if the Nazis became martyrs. Now, of course, a trial that was high politics, masquerading as law, also would have made martyrs of the Nazis. But if, contrary to the critics, the Nuremberg trial did not offend legal principles, the superiority of this method for dealing with the Nazis could not be questioned. Now, ironically, the Nuremberg trial appears vulnerable when it's measured against the principle that Jackson believed made judicial procedures preferable to political executions or summary justice. As Jackson contended, the production of proof of a criminal act is critical. That is true. Nobody disagrees with that. But it's also important that the evidence be presented to an impartial judge. The problem was that the Nuremberg Tribunal was comprised only of representatives of Allied countries, of the 4 Allied countries. Moreover, the Soviet participants, because of their nation's involvement in aggressions against Poland, were particularly interested in having the Nazis assume the blame for crimes against peace. Now, a trial by such a tribunal, one would think, could hardly be conducted fairly or impartially. And I should point out that there really were no compelling reasons for the failure to secure the participation of countries neutral to the conflict, or for failing to include representatives of the vanquished state on the tribunal, namely Germans who did not belong to the Nazi party. There were no good reasons for the failure to do this. Jackson did try to give some reasons, but they actually don't hold water. Despite this, in spite of its organizational flaws, the Nuremberg trial was regarded even by its critics and German citizens as a model of forensic fairness. Everybody agreed that the trial was conducted fairly, despite these organizational flaws. And this perception was owing to the extraordinary efforts that were made to ensure due process and to present unimpeachable evidence and to render verdicts based upon this proof. More specifically, the prosecution's case was based upon documents that were culled from Nazi files rather than rhetorical testimony, which actually would have made for a more dramatic case. Problem is, Jackson said it would not be convincing to people. It was thought by Jackson that witnesses, many of them persecuted by and hostile to the Nazis, would always be chargeable with bias, faulty recollection, or even perhaps perjury. Prosecution documents were also given to the defense counsel in advance of presentation in court. These lawyers were chosen by the defendants. They weren't appointed, they were chosen by the defendants, and they were paid, fed, and housed by the military government. A transcript of court proceedings was furnished daily in German to each counsel. Access was provided to documents not used by the prosecution, and the defendants were granted the deposition or presence of any witness that had information relevant to their defense. Finally, the Germans were afforded both the common law right to testify in their own behalf and the continental right to make an unsworn statement not subject to cross-examination at the conclusion of the proceedings. And I should point out that Jackson was actually responsible for several of the policies relating to the conduct of this trial, most notably the decision to use documentary evidence instead of rhetorical testimony. He had an awful fight with his assistants who wanted to use rhetorical testimony, witnesses, because the media was there begging for a rhetorical testimony, and Jackson said this is going to hurt us in the long run, and he said we should stick to the documents even though the press is going to be bored. And in the long run, I think he was right. Jackson was also responsible for some important things that did not occur. More specifically, he persuaded Francis Biddle, who was an American member of the Nuremberg Tribunal, to relinquish chairmanship to the British. Biddle was very anxious to assume chairmanship. He thought it would be good for his career. But Jackson convinced him that it would not look good for the Americans to have the chairmanship of this tribunal. It would look like a purely American enterprise. So that was one thing that, another instance of Jackson helping the trial to look fair. Another example of Jackson's influence, he convinced Jewish leaders that a strong Jewish presence on the prosecution team might actually foster Nazi martyrs by making this appear as a vengeance trial. Now, taking all this into consideration, even critics of the trial agreed that the Nazis had ample resources and opportunity to defend themselves. The Nazis offered evidence for nearly 5 months compared to the prosecution's 3 months. Jackson actually believed that the Nazis had an opportunity to say too much. As the tribunal ruled, I think it was during Jackson's questioning of one of the Nazis, that the tribunal ruled that the defendants could take as much time as they wanted to answer questions. So you ended up having Hermann Goering going on and on and on, and Jackson becoming incredibly frustrated, not being able to attack as any prosecutor would want. And Jackson's belief that this ruling risked turning the proceedings into a Nazi propaganda event actually forced him to lose his temper at the trial, and at least temporarily, his outburst in court hurt his reputation at the trial. I will argue later that it didn't hurt him in the long run. Critics also concede that the evidence justified the convictions. The evidence presented justified the convictions. That is, so long as the law under which the defendants were convicted was not retroactive, which I'll get to momentarily. Now, the most convincing demonstration of impartiality came with the acquittal of 3 individuals, Schacht, Van Papen, and Fritsch. They acquitted 3. Yet, the presence of formal or procedural justice did not ensure the success of the trial. It was also necessary that it not offend the fundamental principle of legality, that crimes not be invented after the fact. Critics contended that the law applied at Nuremberg was patently retroactive, since it violated existing tenets of international law. The first problem with the trial was that the Allies were seeking individualized punishment. They were attempting to convict and punish individuals. This violated something called the Act of State Doctrine, which specifically exempts an individual from prosecution by another nation for violations of international law committed in the exercise of official duties. The consequence of this tenet is that international law usually acknowledges only collective responsibility, which is illustrated by the fact that the usual sanctions of international law, namely reprisals in war, are directed not against the individual whose conduct was illegal, but against the home state of the offender. The retroactivity problems with the trial went beyond the attempt to seek individualized punishment for acts performed in an official capacity, for it was questionable whether the Nuremberg defendants committed any illegal as opposed to immoral acts. The most controversial charge in the indictment, ironically, was the one Jackson regarded as Nuremberg's greatest legacy, namely crimes against peace or waging a war of aggression. It was largely through Jackson's efforts that this charge was incorporated into the Nuremberg Charter, as he insisted on its inclusion over strong Allied opposition. Jackson's case for the illegality of aggressive war stressed the significance of the Pact of Paris, which is better known as the Kellogg-Briand Pact of 1928. In Kellogg-Briand, most of the nations of the world, including Germany, Italy, and Japan, condemned recourse to war for the solution of international controversies, and they bound themselves to seek settlement of disputes only by peaceful means. And Jackson emphasized that this treaty was preceded by several international agreements declaring the illegality of aggressive war, thus evidencing, in Jackson's opinion, the evolution of an international custom outlawing aggression. Jackson's argument for the illegality of aggressive war was severely criticized, however, because the practice of states between the signing of Kellogg-Briand and the end of the Second World War actually compromised the legality of the aggressive war charge. Critics of Jackson's position, most notably German citizens, pointed to numerous acts of international warfare which were arguably aggressive, and I can just name a few. For example, the Soviet and Japanese invasion of Manchuria, or Italian aggression against Abyssinia, followed by British and French recognition of the King of Italy as Emperor of Italian East Africa. Finally, the intervention of Italy, Germany, France, and the Soviet Union in the Spanish War. Furthermore, the initial responses of the prosecuting nations to Nazi aggressions did not suggest recognition of an international crime. That is, indispensable raw materials were still traded to the aggressors. German aggression upon Czechoslovakia was followed by the Munich Agreement, and the United States responded to the war upon Poland with a formal proclamation of neutrality. So the argument that customary international law had outlawed aggression was unfounded because custom implies usage or near continuous conformity of behavior, which just did not occur. Flagrant violations of anti-war agreements and acquiescence in acts of aggression revealed that Kellogg-Briand had no legal force whatsoever. The controversy surrounding the charge of aggressive war was exacerbated by a separate but related count, namely conspiracy to wage aggressive war. Like the aggressive war count, the inclusion of this charge in the charter was the result of Jackson's insistence against Allied opposition. Jackson found the doctrine of conspiracy attractive because it made possible the prosecution of individuals who may not have actually participated in specific acts of international aggression, but whose cooperation was vital to Nazi wars of conquest. Use of the conspiracy doctrine was criticized for two reasons. First of all, it had no basis in international law. Most European nations had rejected the conspiracy doctrine in the 19th century. Second problem was that the potential for abuse was great with a doctrine that required no evidence of illegal action. Understandably, the tribunal was wary of these most controversial aspects of the indictment, and they acted to limit their impact. For example, the tribunal rejected the prosecution's argument that any significant participation in the affairs of the Nazi party or government is evidence of a participation in a conspiracy that is itself criminal. The court said that's too broad. The tribunal insisted that an individual be part of a concrete plan to wage war and have a sufficiently high position to exert influence upon this plan in order to be convicted under this conspiracy charge. The result of these efforts by the court to limit the impact of the more controversial aspects of the trial was the acquittal of 14 of 22 defendants on the conspiracy charge. And among the major war criminals, only Hess, sentenced to life imprisonment, was found guilty solely on the aggressive war counts. All but one of those who was sentenced to death had also been convicted of both remaining charges, namely war crimes and crimes against humanity. The integrity of the trial, however, could not be ensured by efforts to mute its most controversial aspects and by the mere fact that most defendants were found guilty of other crimes as well. What I'm saying is that it was essential not only that those remaining charges not offend legal values, but they be of such moment as to vindicate the Nuremberg effort or to compensate for its shortcomings. They have to be of such moment that they overshadow the more political aspects of the trial, because everything I've said so far has suggested that the trial was a political trial. Prosecutions and individualized punishment for war crimes or violations of the laws of war were generally accepted as part of customary international law because of the Hague Conventions. Even critics of the trial accepted the legality of the war crimes charge. And German war crimes were undeniable and numerous, and they included the murder of captured Allied airmen and prisoners who had escaped but had been recaptured, the plunder of occupied territories, and the taking and shooting of hostages. But the count that actually served to vindicate the Nuremberg effort was the one that had not even a pseudo-legal basis: crimes against humanity. There was nothing in the way of an international convention remotely similar to Kellogg-Briand relating to crimes against humanity. This count was included in the indictment in order to punish the Nazis for persecuting German citizens on political, racial, or religious grounds. These were cruelties that preceded and continued during the war. The legality of this charge was vulnerable because international law does not permit punishment by military occupants for crimes committed before the commencement of hostilities. Moreover, occupying nations are precluded from prosecuting acts perpetrated by nationals of the vanquished state against their own citizens. Determination of culpability for those acts is generally considered the exclusive sovereign concern of the authorities of that state. They should have been tried by Germans, according to international law, for crimes against humanity. In order to make this count less controversial, the tribunal, in clear disregard of the charter, limited itself to crimes committed after 1939, the commencement of hostilities, and they would acknowledge the commission of crimes against humanity only where proof also fully established the commission of war crimes. Yet, these efforts could not completely disguise the fact that the defendants were being prosecuted on a novel charge, that this was in fact, ex post facto legislation. The lack of a legal justification, however, did not compromise the legitimacy of this aspect of the trial. There was no significant scholarly criticism of this charge. And this is because it was believed that punishment was warranted because of the enormity of Nazi offenses against German citizens. As Jackson argued, history does not record a crime ever perpetrated against so many victims or one ever carried out with such calculated cruelty. The Nazis' cold, systematic, and brutal extermination of non-Aryan Germans, especially Jews, and domestic opponents was so extraordinary that no moral or legal argument could excuse the defendants. So punishment in the absence of law certainly did not conform to legal values. It was ex post facto. But in this case, it did not offend these principles because the prohibition of retroactive legislation is based on the ground that the actor might, at the time when he performed the act, have believed that he was entitled to perform it. Now, the only reason no international law or convention made criminal the mass extermination of peoples was because such a practice was just unthinkable before the Second World War. Now, since the Nazis could not have fairly thought that genocide of a segment of their population was undeserving of the most severe form of individualized punishment, a retroactive law setting aside the active state doctrine and making this practice criminal was acceptable. Indeed, failure to execute the Nazis, those responsible, would have been a denial of justice. The perpetrators of the Holocaust, in other words, had to be punished. Due process, however, had to precede the meting out of punishment, as the proceedings substituted a reliable process of determining guilt for what was the most likely alternative, namely private uncontrolled vengeance. And those who would have testified to the wisdom of this argument included Hess, whose life was spared by his being found innocent of crimes against humanity and war crimes, and Fritsch, who was freed because he was cleared of the same charges, as well as conspiracy to wage aggressive war. So, to conclude, the Nuremberg trial fulfilled the functions that Jackson had hoped it would. It meted out deserved punishment after demonstrated proof of criminal activity. And in retrospect, despite what Newsweek says about a resurgence of fascism in Germany at this time, which is disturbing, but I think it could be that they're overstating it, the trial also prevented the creation of Nazi martyr figures by exposing fully the atrocities of the Third Reich. Only a trial, as Jackson argued, with its emphasis upon disclosure and explanation, could document these crimes and reveal the sterility and the reasons and defenses advanced for such murderous behavior. But let me end it there. I hope that there's enough time for questions.
Curious as to, was there a particular meeting among the four allies in power to start the war?
Yeah, what the Americans did, Jackson was sent as the American envoy to get this charter, the Nuremberg Charter together, and they met, I can't remember when Jackson first went to London, I think it was, when they drew this up. But it took some doing, because Jackson at the time wanted to get the aggressive war charges in there, and he fought awfully hard with the Allies, who said, we don't want any part of this. But Jackson insisted, if the United States is going to be part of this, we're going to have these aggressive war charges in here. But yes, the tribunal had to be based on a charter, because there was nothing in international law. The United Nations was created in '46. There was no International Court of Justice, so they had to have some legal basis. They had to have something in to empower this court. What I'm arguing is that they should have included more nations than the Allied powers. Now, some attorneys made the argument that, well, this is no different. So what if it's just the Allied powers that are prosecuting these individuals? That's no different from the state prosecuting criminals. Actually, that analogy doesn't hold up, if you think about it, because the state has less of an interest in prosecuting individual criminal defendants than, say, than did the Allied powers in prosecuting their enemies from a devastating world war. But they did have to have a legal basis, and they spent considerable time drawing it up in London. This didn't solve the legal problem. People said it doesn't. There's no justification. You're creating it specifically to prosecute these Nazis. In fact, the Soviets wanted just to target the Nazis. For obvious reasons, the Soviets wanted the charges directed just at the Nazis, because the Soviets were guilty of aggressions against Poland also. Jackson said, we don't want it stated specifically against the Nazis, we're going to state it generally. He insisted on that also.
Is there an extensive film library of Jackson's work as a chief prosecutor? And second question, why President Truman picked Jackson over somebody else.
Yeah, I think there is considerable film taken of the Nuremberg trials, and I think a lot of it is at the Library of Congress. I never did ask the people at the Library of Congress to bring forth the reels, because I didn't have the equipment, and I wasn't about to ask them if they had the equipment to let me view this. But I think there is extensive documentary evidence at the Library of Congress, if you're interested. And anybody can use the collections now. It's open to the public. When I was using it, it was restricted. When I first started using it, it was restricted. There are some documentaries out that I actually saw in Arts and Entertainment before coming out here. And then, of course, there's Judgment in Nuremberg, starring Spencer Tracy, who immortalized Justice Jackson, which I'm embarrassed to say I have not seen. The second question relating to why Truman picked Jackson, this is, it's kind of touchy, because I'll argue this evening, that there was some political motivation on Jackson's part for accepting this assignment. Namely, FDR had essentially promised him the Chief Justiceship when Stone stepped down. And Jackson was led to believe that he was next in line, because Truman actually intimated that he was going to appoint Jackson. And I think Jackson realized that if he's going to increase his chances with the new president after FDR died, he best go to Nuremberg at Truman's request. Now, the reason Truman requested him specifically, I think, had to do with a speech that Jackson made before. I can't remember the international organization that Jackson was speaking before, but Jackson actually wrote a beautiful speech arguing that if we were going to try the Nazis as war criminals, we had best make sure it's not a political trial. And he outlined what the countries had to do in order to avoid making it seem a political trial. Ironically, he ended up insisting on these aggressive war charges, which were the most political aspects of the trial. But I think it had to do with the speech, because Jackson made a very compelling argument concerning how the Allied countries should go about approaching this very sensitive issue. Yes.
Did your research indicate that the reason that Jackson was not appointed the Supreme Court Chief Justice is the fact that he and Black had a major difference of
Blood feud, as the press reported? Yes, in fact, I do. Truman denies this. I'll speak tonight about this cable that Jackson sent to Truman from Nuremberg. It was at Nuremberg that Vincent ended up being appointed, and Jackson found out, to his bitter disappointment, that he had lost the Chief Justiceship. But he was convinced that the news reports were accurate. That is, that he assumed it was Black, Justice Hugo Black, that was telling the president that if you nominate Jackson Chief Justice, we're out of here. It was actually Douglas, I think, and Robert Hannigan, who was the former Democratic chairman of the committee. They were the ones that were scheming against Jackson, and I think Douglas may have actually, I don't have any evidence to support this, but the argument is that Douglas said, I'm not going to stand for this, and we do not want Jackson. And so Truman, I think, thought better of calling Douglas's bluff, and thought, well, I'll just, I assume he made no promises to Jackson. I don't think there was a quid pro quo, that if you go to Nuremberg, I will appoint you chief. But I think there was an unspoken promise. And what happened is that Truman was afraid that there would be some real controversy on the court if he were to appoint Jackson, and so he thought better of it and said, well, I'll appoint Vincent, who was going to bring the court together. As it turned out, things were calmer, and Jackson actually, though he denied having any designs on the Chief Justiceship, he essentially conceded that he had them by saying, well, things were better partly because the rivalry between Black and myself over the Chief Justiceship was now settled. But it was, I think, because of Black, or because of Douglas, that Jackson penned this incredibly vitriolic memo to Truman. And then he had sent a public one to the Senate and House Judiciary Committees, which the press got wind of, obviously, and it really was, Jackson took a beating in the press after this because of those.
see another hand. You made a comment about the outburst of the trial by Robert Jackson, how that hurt him initially as a vindicated subsequently, but you comment on that?
What I mean by hurt is that the press, they were looking for things to talk about because they weren't using rhetorical testimony. So what do they focus on? Jackson lashing out at the tribunal for saying you're allowing these guys to drone on and make this a propaganda event. And so, of course, the press focuses on this. I don't think, Dennis Hutchinson at the University of Chicago says that it really hurt Jackson's reputation, but I think even in the short run, I'm not really convinced that it had any real effect on the outcome of the trial. I mean, the crimes against humanity charge are just so strong, despite the fact that it was ex post facto, that Jackson's outburst really had no bearing on that.
Well, there are two things that are true. Probably someday the Chicago Cubs will win the pennant, and for sure, research is going to go on about Robert Jackson's work as a member of the court and also at Nuremberg. If you can, please pick up Dr. Hockett tonight. He'll be lecturing again at 7 o'clock, the second floor of the library building here. For your colleagues who might not have been able to come today, we invite you to come back to campus tonight. So thank you very much for coming. And
thank you.